Classification of a company's workers as employees or as independent contractors continues to be viewed as a widespread issue. Just about everyone knows that most taxing and regulatory agencies do not favor independent contractor treatment. These agencies believe, sometimes correctly, that the independent contractor classification is subject to abuse. In fact, federal and state regulators are inclined to presume that most workers should be classified as employees, even if they may actually be called independent contractors. And that makes sense. After all, a person who is paid as an independent contractor does not pay his or her taxes until the filing deadline the following year. In contrast, payments to employees are subject to Social Security and Medicare taxes, which are collected on wages immediately. In a similar vein, self-employment taxes paid by independent contractors have been one of the most notoriously under-collected taxes. As a result, there are both timing and revenue differences between employee and independent contractor treatment. These lead to a great preference by the IRS as well as by state regulators in the area of unemployment compensation and workers' compensation in treating all workers as employees and subjecting them to withholding.
On the one hand, the issue of classifying workers as employees or independent contractors has become more pivotal than ever for businesses. But on the other hand, most companies, and most of our viewers, are more interested in growing their revenue and in pushing out new products and services. Joining us once again is Barry J. Waters, who counsels and defends businesses as a partner in the New Haven office of Murtha Kalina LLP, at a time when the front page headlines are preoccupied with health care repeal and immigration reform.
In today's competitive environment with rising healthcare costs, employers are looking for ways to get work done without employing employees on a full-time regular basis. So we do have the gig economy where we have people working part-time, we have people working as independent contractors, and obviously this is going to keep costs down for companies.
A few years ago, with the enactment of the Affordable Care Act, we heard that full-time employees were those who worked, on average, 30 or more hours per week. Barry Waters observes how that guideline had an impact, beyond health care benefits, on workplace practices in general and on worker classification in particular.
So, the problem has been that the government realizes how the economy is changing and how worker classification is affected, and so are private lawyers. During the Obama years, there was a heavy emphasis on enforcing the labor laws, particularly misclassifying employees as independent contractors. Of course, now we have the Trump administration, and it remains to be seen how rigorous the enforcement actions will be.
Of course, the issue of worker classification is driven by more than economics and regulation. In recent years, many businesses want to ride the recovery by hiring so-called temporary workers. For instance, in this so-called gig economy, many employers, by following the example of Uber and Lyft and hiring a so-called on-demand workforce, are now open to attack from their workers as well as from regulators.
Well, the problem with the misclassification issues are we're dealing with labor laws that were passed in the 1930s. Business has changed dramatically, particularly in the last 10 or 15 years. The way people are classified has changed dramatically. But the regulators are out there, and so are private lawyers, looking to claim that what you call an independent contractor is actually an employee. And, of course, there are serious penalties if they're right and you're wrong.
On the one hand, we've got an entire alphabet soup of federal and state agencies that regulate and audit a business's arrangements for tax withholding, health care, pension, and unemployment insurance. But on the other hand, it seems as if we're also seeing a lot of issues, including class action lawsuits, that are triggered by those workers who agreed to serve as independent contractors who are now claiming they are employees.
Well, the arrangement of independent contractor initially looks very attractive to the employee or independent contractor, as it were. The person who's agreeing to an independent contract is getting paid 100%. Maybe not thinking that they have to pay taxes the following year and they have self-employment tax and that sort of thing. But initially, it's gratifying to get your $1,000 a week. 100%, and you're not worried so much about the benefits and long-term effects. But something goes wrong. You feel you're mistreated. You might even be fired. And then suddenly you're not happy about the situation, and perhaps you get the ear of another employee who knows a lawyer, and pretty soon a group of people are claiming they were misclassified as independent contractors.
Of course, in many ways, it is logical for companies to presume that these workers are independent contractors. After all, the individuals signed on to work as independent contractors. In most cases, those workers can make themselves available for work whenever they want. In addition, in many cases, they can also work for competitors. So, the question arises, why can't businesses continue to treat those workers as independent contractors?
So, under the labor laws, if somebody's working for you, the government and private lawyers, if they take it to court, are going to say, we assume these are employees. That's what the law says. We assume employment. Now, you tell us why this person is not an employee and is actually an independent contractor. The fact that the person signed an agreement with a title across the top that says independent contractor is really a very minimal factor in determining whether that relationship actually exists. So every state has its own labor laws. The federal government obviously has labor laws, and you have laws regarding wages. You have laws regarding independent contractor status. You have laws concerning the payment of unemployment benefits. The agencies, whether state or federal, have varying tests on what an independent contractor is as opposed to employee. But it really boils down to simple factors, and they're factors of control. Does the employer control the means and method of work? Does the employer tell the person how to do the job? Does the person report to the regular business of the employer? Does the employer exercise financial control over the arrangement? Is the person set up as an independent business? So those are the basic factors under all these tests across the country before any agency that are factored in. Some tests are 15 or more factors, but it essentially boils down to those factors.
In other words, is it possible that a worker may be viewed as an independent contractor under some tests, but may be classified as an employee under other regulatory standards?
It's possible that someone might be considered an independent contractor, say, in the state of Iowa and not in the state of New York. That's certainly possible. But if it walks like a duck and sounds like a duck, it's probably a duck under any law.
In terms of a presumption, what about the situation where an independent contractor only provides services to one company? Are they still a contractor rather than an employee?
So if an independent contractor is providing services only to one company, that's a factor that suggests they're more likely an employee. Very interestingly, just this week, the Connecticut Supreme Court found in a case that an independent contractor providing services to only one company remained an independent contractor. That contractor was free to provide services to other companies and chose not to.
More than a decade ago, we provided coverage of an independent contractor dispute for ERISA purposes. In the Vizcaíno case, two people were performing similar tasks for Microsoft. But the red flag was that one individual was classified as an employee, while the other one was treated as an independent contractor.
Well, it is a problem if you're performing the services in the regular place of employment of the employer, and you're performing the same services as employees, and you're working side by side. There's no real way under the law to distinguish that person's status from an employee, so that you can be exposed for large damages in that situation. It does happen quite a bit when employers choose to hire temporary employees. Sometimes those temporary employees stay on for years, and they're doing the same work as regular employees. So whether you call them an independent contractor or your position as a company as, well, they're not my employees, they come through a temporary agency, guess what? You have a problem because they can be considered your employees. So, the problem is that the independent contractor could appear to be extremely happy with the arrangement and never complains about it. But later on, when they learn they could have been eligible for benefits that they weren't eligible for as an independent contractor, then they're going to have large incentive to say, I really was an employee. They misclassified me. And under the law, it's the employer's burden to show that the person was an independent contractor, and it doesn't matter that the person performing the services had agreed to claim that he was an independent contractor.
Since that time, many large organizations have adopted new systems for classifying their workers, but those processes tend to apply to the individuals who they employ or with whom they have contracts. But what happens when the larger enterprise contracts with a smaller business that hires their own independent contractors? In a recent court battle in California, Macy's West Stores Incorporated, along with the department store's logistics management company, Joseph Eletto Transfer Incorporated, agreed to pay $4 million to settle a class action misclassification lawsuit brought by over 600 truck drivers and their helpers. Of that amount, Macy's agreed to pay $3 million, and the logistics company will pay $1 million in settlement of the claims by the workers. According to the drivers and helpers, the department store and its delivery company misclassified them as independent contractors in violation of the California Labor Code. According to the plaintiffs, although the drivers signed independent contractor agreements with the logistics management company, the relationship was heavily regulated by the department store. Specifically, they alleged that the drivers and helpers were required, 1, to display the Macy's logo on their trucks, 2, to wear Macy's uniforms, 3, to follow Macy's delivery schedules, 4, to leave their trucks at Macy's sites at the end of the day, and 5, to be evaluated on whether they met Macy's standards and expectations of delivery and customer service. Barry Waters explains that it is possible, in some situations, that a larger organization will be regarded as the real employer of the workers.
Well, the law is going to look at who controls the means and method of work, who is telling the employee ultimately what to do. So you could be a subcontractor, you could work for a subcontractor, but if the contractor is providing all the instruction as to how the job is done, when it's to be done, then you could be considered the employee of that company one step removed. There is something in the law called a joint employer status, and that may be true in terms of any of these labor laws. Even a discrimination case could be made against two so-called employers, even though on paper the employee worked for the lower level company. The larger companies are always going to have to be on guard against these lawsuits because they're the ones who can pay a judgment. They're the ones who can pay a large settlement, and particularly in a class action situation. So private attorneys, particularly, and the government as well, are looking to the larger companies, and they're looking industry to industry. If they find a problem, a misclassification as an independent contractor or misclassification as exempt instead of non-exempt employee, then they're going to target certain companies in certain industries. And so if you learn one of your competitors has been targeted, be careful, watch out.
Let's look at a recent case that raises similar issues. RDI is a furniture delivery company that provides last-mile delivery services for large retail furniture companies. RDI contracted for delivery services with independent contractors, so each worker incorporated his or her own business. Those workers all delivered furniture for RDI for several years on a full-time basis, working approximately 60 hours per week. The contract precluded the workers from performing any delivery services for RDI's competitors during the contract term and for 3 years afterward. In addition, RDI required that the workers wear uniforms and display signs on their trucks bearing either RDI's logo or the logos of RDI's customers. RDI deducted from the plaintiff's pay the costs of uniforms, truck lease payments, and damage allegedly done to customers' property in the course of their deliveries. RDI also regulated how the workers loaded the furniture on their trucks, which customers they delivered to, and specific windows of time in which they were to deliver their goods to customers. And finally, RDI required that the workers follow prescribed routes to reach their customers and use global positioning system devices to ensure that the plaintiffs did not deviate from their assigned routes. The workers filed a class action claiming that they had been misclassified as independent contractors and were owed overtime pay, treble damages, and attorney's fees. Yes, it's confusing about which test you use to determine whether a worker is classified as an employee or an independent contractor. But it sounds, from this case, as if in some circumstances it may also be difficult to determine who is the employer that's liable.
So RDI is a very interesting and somewhat unique case because most employers, as this one did, the upper-level employer, let's call it, not the nominal employer, felt that if they required, in order to do work for us, you have to incorporate. Each of these individuals formed his own corporation to make the deliveries. Then they were somehow shielded from any liability because they were not the direct employer. And typically, one of the factors in determining if someone is an independent contractor is, do you own your own company to provide these services? Well, in this particular case, because of all the other factors that the upper-level employer required, what routes you would drive, what your labeling you had on your trucks, that you had to wear the company uniform, and I think importantly, they had non-compete agreements which said you can't deliver for anyone else. So in all material respects, they were employees, even though the upper-level employer felt shielded because of the incorporation. And the Massachusetts Supreme Judicial Court disagreed.
I suppose if a large organization insists that the workers wear the uniform of the franchisor, like Domino's Pizza, or if they paint their truck with the name of the RDI Logistics, then they could be liable as the employer.
So the problem here is if you are controlling how the work is done, where it's done, when it's done, you might be considered the employer for all kinds of purposes. You know, a typical situation might be a franchisor-franchisee arrangement. You might have a restaurant in Montana. That restaurant is actually owned by a franchisee. So the franchisee hires the employees. You say, we don't have anything to do. We don't even know who those employees of the franchisee are. You can be considered the employer if you're controlling how the operation is run. And this is true under tort law slip and fall cases. It's true under the labor laws. It's a general concept that don't fool yourself. If you're directing how the work is done, you could be considered the employer. So the case of Uber and Lyft providing the similar circumstances, those drivers consider themselves independent contractors. The employers consider them independent contractors. But when there is a claim, then someone is looking for the real employer, as it were, to pay the freight. And if there is an accident and a passenger is hurt, the person driving the car may not be able to pay a judgment. So there's a huge incentive financially to claim that Uber is the actual employer and responsible for training the drivers. If there's a negligence claim, just as if they were actual employees on the payroll, the employer can be held liable.
In recent years, both the IRS and the Department of Labor are now sharing information, including the exchange of taxpayer data and audit results with state and local regulators. As a result, it is possible that businesses that engage in workplace arrangements with independent contractors are going to face even more scrutiny from taxing and regulatory authorities.
The problem is that if you have a certain kind of arrangement and you're a large company, you probably have that arrangement in many states, and there are many laws under which that arrangement could be challenged. So if you have a challenge in New York, consider the possibility that you may also have the same challenge in Pennsylvania. So in dealing with the regulators, you have to make a practical judgment based on the specific facts, hopefully with legal advice, to determine whether you have a situation that you want to resolve with the regulators quickly and inexpensively so that you snuff out the fire. So if you're dealing with a state regulator, it's quite possible you can resolve a case fairly favorably and not hear another word about it. The problem is if you have employees misclassified either as exempt when they should be non-exempt, or as independent contractors when they should be regular employees, you probably have that same arrangement wherever you do business. And private lawyers are not bound by state boundaries. They're looking to bring a class action in as many locations as they possibly can. So if they see that you have a problem in New York with the way you've classified with someone, they're then going to look at where you do business across the country. And they're going to make sure that you have that same problem everywhere you do business. Supposing you're a national restaurant chain and you have 1,000 assistant managers across the country, and you settle a case based on the assistant manager in New York not being exempt, and you were treating him exempt. Well, guess what? You have the same problem wherever you do business. So you want to take a look at the whole playing field before you decide what's the best way to resolve it.
Think about our viewers and your clients. Let's say that a company had a salesperson in a faraway state. He or she was treated as an independent contractor. And now that worker has filed a complaint with his or her state's unemployment agency or their worker compensation board. As financial executives, our viewers like to examine the risk versus the benefit. Their initial reaction would be just to pay the $86 fine rather than hiring counsel to contest the reclassification.
Well, if you don't contest, what you have to worry about is whether the same claim shows up in another forum in the same state, another agency who's getting the information, or in another state, or worst case scenario is that a private lawyer on the employee's side or the independent contractor's side decides that there's a big case that can be made here. So you do want to have legal counsel, even if it's a very small fine. Look at the whole situation, determine who else in your workforce might be affected by this. And in the short term, in the immediate situation, it may cost you more hiring a lawyer. Obviously, it will cost you more than $86. But in the big picture, you might be saving money.
As accountants and financial professionals, our viewers are accustomed to hearing and receiving incentives from the government. We'll go easy on you if you come forward to us and reclassify your workers as employees. Now, on the one hand, the IRS continues to promote its so-called voluntary classification settlement program. On the other hand, it may be easier and more productive to conduct an internal audit.
Well, before you decide whether it makes sense for you have to understand what potential problems you have. And the best way to understand that is to do internal audits. You could go for the amnesty just like you could plea bargain if it were a criminal case. I don't do criminal law, but some of my colleagues do. But really, you should know what your potential problems are before you reach that stage. So we recommend that you do regular audits of your positions. Look carefully over and over again when you're hiring people, when you're keeping people on longer than you initially thought you might. Are they really independent contractors? Are they really exempt? One typical situation that we see, in order to be exempt as an executive under the law, and this is true in almost all states and it's certainly true under the federal law, you have to supervise 2 or more employees. Well, business changes, departments change, so you might have someone who legitimately was exempt for a number of years and then now has just one direct report. Bingo. That supervisor is no longer exempt, and no one looked at it. So that's a way you can get in trouble if you're not auditing your positions on a regular basis. And you know what? It really takes someone from the outside, in my judgment, to help you through that process, someone who is familiar with the labor laws.
Now, that may make sense in terms of a business's current workforce, but as an attorney, Barry Waters can tell us to what extent do organizations also need to consider their former workers? In other words, is reaching a settlement agreement with the government binding on your former independent contractors?
Well, you have to work your way through these investigations and then settlement conferences very carefully. You have to understand who other than the employee or independent contractor that's at issue might be affected. So you have the problem that people that formerly perform services with you, whether as an employee or an independent contractor, can be considered part of a claim. And generally, under the labor laws, the government or private lawyers can look back 2 years. So your former employees can claim that they were misclassified.
Well, the good news is that as the economy continues to expand, many businesses are growing, and they are starting to bring new workers on board. But as they do onboarding, many organizations want to know if there is anything that they should do now to avoid trouble later.
Well, when I speak to our financial executives within our client group, what I tell them is, look, it may seem a good deal to classify people as independent contractors or claim that they're exempt because you will reap short-term benefits from doing that. But you got to think longer term. And you have to be aware that there are all kinds of agencies out there who might audit you, and private attorneys who might bring class actions. So the best protection against claims is to do a self-audit, to also, when you're onboarding people, be realistic about what their status is. So if you bring someone in and you say, well, here's an independent contractor, they're willing to sign an independent contract, and they're going to sit right next to a regular employee and do the same work as a regular employee, they're probably not an independent contractor. So don't fool yourself in the short term because you think you will benefit from it. In the long term, you may have to pay a large price for that decision.
A worker signs an agreement. It covers what he or she is expected to be doing for the business. But sometimes things change. How often should companies be reviewing or going through these independent contractor arrangements?
Well, I think your human resources department should be looking at these issues all the time. But in most companies, you have at least an annual review function. And some companies have a 6-month review. So I recommend that when you review a performance of an employee, that you also review what that employee is doing, who the employee is supervising, who the employee is being supervised by, and how are we classifying them. Ask yourself, every time you do that performance evaluation, is this person classified correctly? So the thing is, when you hear about a problem, through some trade association, through discussion with one of your competitors, through news reports that a competitor of yours has a problem, that's a good time for you to do an external audit. And in fact, when you're dealing with the government, they want to know that you have done an audit, that you've been careful, that you have corrected possible mistakes. So even if the government feels that there are some issues, they are more likely to come to a good resolution with you if they think you've been diligent and you're doing your best to comply with the law.
Businesses, like all organizations, are made up of people, and people are, of course, human. As a result, companies often overreact when someone, even a trusted employee, brings a lawsuit or files a complaint. For instance, the RDI lawsuit occurred after the founder and president of the company learned that the drivers had started discussing whether they were misclassified as independent contractors. As a result, he terminated the contract of the driver who spoke to his colleagues. It's probably not surprising that the driver, besides joining the class action on worker compensation, also asserted a claim against his employer for retaliation.
It's not surprising, actually, particularly in a small company was run by one entrepreneur, to have a strong reaction. I think a natural reaction is, in the RDI situation, hey, you agreed to this independent contractor situation. You were happy with it for a long time. It served your purposes as well as our purposes. Why are you doing this to me? And then to overreact. Retaliation is the hardest claim in employment law to defend. It can take many forms, and there just has to be some connection between the claimed illegal behavior and the reaction.
In terms of retaliation, it may not make a difference whether A, the employee believes a legally protected right has been violated, or B, the employer takes a negative action against the employee.
In a lot of these retaliation claims, what the court is looking at is a timeline. The discrimination claim was filed on a Tuesday, and on a Friday, the person is transferred or is given discipline or is terminated. So there is a probable causal connection just on a temporal basis. However, the reaction, the retaliation, can occur later. As it has been said, revenge is a soup best served cold. So the retaliation may come at a later date. It's going to be harder for the employee to prove the connection between the discrimination complaint and the later action, but it's not impossible. There is no bright line on when the timeout has occurred.
In a similar vein, recent statistics indicate that A, retaliation is the most frequently filed charge against employers, and B, at least in discrimination cases, workers are more likely to be successful with a claim of retaliation than with their underlying discrimination charge.
It's not really surprising that retaliation is the stronger claim than the underlying discrimination claim, because there can be evidence of discrimination, but a judge or a jury may decide in the end or a state agency that there wasn't enough evidence to prove the claim. But it's not frivolous. It's not without some merit. So in those situations, the employee might lose the discrimination claim, and the employer might be really angry about having to defend itself against a discrimination claim and lash out at that employee in ways that the employee can claim are retaliatory. Change of job, change of pay, termination is the ultimate retaliation, obviously.
In a recent case, a corrections officer had been employed by the State Department of Correction for over 20 years. In March of 2011, Aime filed a race discrimination claim with the Massachusetts Commission Against Discrimination, and soon thereafter filed internal complaints of unfair treatment by his supervisors. A few months later, the Department of Correction informed Aime that he was being transferred from working at a pre-release center in Roslindale to a hospital correctional unit in Boston. The superintendent in Roslindale had requested that Aime be reassigned within a few weeks of the filing of his discrimination complaint based on his repeated conflicts with his supervisors. Of course, many workers believe that asserting a claim of discrimination essentially immunizes them from further disciplinary action by their employer.
Aime is not immunized. No employee is immunized because they filed a claim. What you want to keep in mind is you are entitled to expect performance from your employees. They may or may not have a legitimate discrimination claim, but if you focus on the performance and you insist that the employee perform, you can discipline and even discharge. Remember, of course, if the discipline and discharge comes right on the heels of the discrimination claim, it starts to smell a little bit. Doesn't mean that it's wrong.
Let's make sure we understand what constitutes retaliation. In this case, the job transfer did not constitute a material change for Aime. But in other situations, a change in responsibilities or a change in conditions of employment could sustain a retaliation charge.
Retaliation can take many forms. The termination is the obvious one. But a transfer, a change in pay, even being excluded from meetings, in these cases there tends to be a number of factors that the employee would point to. They no longer talk to me. I go to the lunchroom. They won't sit with me. So typically in these cases, you have a pattern of behavior that the employee then claims is retaliatory. This case is very interesting because what was decided is there really was no change in the working conditions. That's what you look at. So Aime had the same pay, the same position, and although he was transferred, he didn't have a longer commute to work. Now, take that same case and tell Aime he now has to travel 60 miles to work, that there may be some evidence there of retaliation.
What about the opposite situation, when an employee's claim of discrimination has been dismissed? To what extent is the employer now immunized from a claim of retaliation?
Even if a discrimination complaint is dismissed, you could still face a retaliation claim. You're not immunized. So even if the claim is dismissed, if there is a good faith basis for the employee to believe that some kind of discriminatory treatment occurred, then they are protected from legal retaliation. Again, that doesn't mean that you can't act against the employee in the normal course in terms of performance.
As a result of a retaliation claim, the courts sometimes extend the statute of limitations for employees to bring a claim. As an attorney, remind us, to what extent is the statute of limitations just legal chatter? Or is it something that companies and their managers need to be concerned about?
Well, the problem is that a lot of these claims are based on what they call a continuing pattern of conduct. So you might have an incident that occurred 2 years ago, and then another incident that occurred 6 months ago, and then another incident that occurred 2 weeks ago. And particularly if you're dealing with the same manager, the claim will be made, you know, what happened 2 years ago at the time, I didn't think much of it. But now, when I put it together with this pattern of behavior, I see that I've been discriminated against over a period of time. And so in effect, the statute of limitations is extended through that pattern of conduct.
Of course, as financial executives, our viewers are also concerned with those employees who become whistleblowers. After all, under Sarbanes-Oxley, companies cannot harass or retaliate against whistleblowers.
There are scores of federal and state statutes which will protect employees from retaliation. So yes, whether it's a financial statute or a labor statute, if the employee is mistreated for reporting misdeeds, a crime or financial misdeeds, then that employee does have retaliation protection. Again, it doesn't mean that you have to freeze and treat that employee now with kid gloves.
You know our viewers. They've got HR departments to handle personnel policies, and they've got general counsel who are concerned with litigation. Murtha's Barry Waters concludes by reminding us what role financial executives can or should play in this process.
I think the biggest problem facing financial executives and companies in general is your frontline supervisor, your next level manager, are the ones who are carrying out the actions of the company. And they're the ones that the employee is going to claim has mistreated them in terms of discrimination or retaliated against them. People do, unfortunately, act emotionally in the workplace. And if a frontline supervisor reacts emotionally, you can be responsible for that behavior.